Hare Krishna. Welcome to Tax YouTube channel. This is C. Rohan Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says, and today we are going to discuss case laws reported to High Court under the income tax law. And both cases are very recently decisions in the month of February and in the month of March. One is related to reassessment procedure and one is related to attachment of the property, provisional attachment of the property. So let's dive into it. Let me allow to share my screen. Yes. So let's move to the first case. ARL Infratech Limited versus DCIT, High Court, Rajasthan. Relevant assessment year 2021-22 to 2026-27. And date of order is 6th March 2026. Let's understand facts of the case. The assessee ARL Infratech Limited was subjected to assessment proceedings for multiple years, that is assessment year 21-22 to 26-27. During the pendency, the assessing officer invoked Section 281B of the Income Tax Act 1961 and passed an order of provisional attachment of bank accounts and assets. So, attachment was made without detailed justification, covering substantial assets affecting what business operations. Very important. Okay, so the assessee challenged the order before the High Court. So let's see what was the issue under consideration. Whether provisional attachment under Section 281B was valid when there was no tangible material indicating risks to revenue and the action was mechanical and excessive. So let's see what were the relevant legal provisions for the given case. So Section 281B, that is related to provisional attachment, empowers AO to attach the property during the proceedings. So preconditions, whatever necessary, are must be to protect the revenue interest and requires the prior approval of the principal commissioner or commissioner. So nature is a drastic power, must be exercised sprangly and with a caution. That is important from the department point of view. So let's see what were the grounds of the appeal. So assessee contended that no objective satisfaction recorded, no evidence of asset dissipation and the revenue risk. Attachment was arbitrary, disproportionate, and violative of Article 14, that is arbitrariness and principles of natural justice, is what contended by the assessee. So let's see what High Court observed and held. The Rajasthan High Court emphasized that formation of opinion must be based on what material. Okay, so AO cannot act on mere suspicion or routine practice. So must demonstrate that the likelihood of the tax evasion or asset diversion. And power under Section 281B is what extraordinary. Should not be used as a tool of coercion. It is a preventive and not a punitive, right? So proportionately principle is that attachment must be limited and relevant to the likely tax demand. So blanket attachment of accounts people's businesses, okay, business operations. So recording of reasons is mandatory. Absence of proper reasoning orders would be invalid. So what High Court held that the provisional attachment order quashed in the given case, and court held that action was mechanical and unjustified and no evidence of revenue risks. So that was in the favor of the assessee. Moving further to principles, what principles laid down by the given case. So Section 281B empowers that power must be exercised sprangly, require objective satisfaction, mechanical approval invalid, proportionately is essential, okay, right? And the business disruption without justification is what? Impermissible. So practical takeaways from the given case is that always demand recorded the means whatever reasons are recorded, we must demand that approval documentation, then challenge attachment where no revenue risk is shown. Wherever there is no risks, revenue risks, then we must challenge that attachment. So use this judgment to argue what attachment is not equal to default procedure. Okay, that practical takeaway we can take from this given case. So moving further, case 2 for the today is Sapphire Foods India Limited versus ACIT High Court Delhi. Assessment year is 2016-17 and date of order 16 February 2026. So let's understand facts of the case. The assessee Sapphire Foods India Limited received what notice under section 148A clause B, followed by orders under section 148A clause D and notice under section 148. So allegation was income escaped assessment, that is for the assessment year 2016-17. So assessee contended that no new material reopening based on existing assessment records is what assessee contended. Let's see in the detail. So issue under consideration was whether reassessment is valid when based on no fresh tangible material and constitutes only change of opinion. So let's see what were the relevant legal provisions. That is section 147, which stands for reopening allowed if income has escaped assessment. Section 148, issue of notice. And section 148A, post 2021 regime. Mandatory pre-notice procedure need to be followed. That is inquiry, show cause, and passing speaking order. And section 149, that is time limits for reopening. So these are the relevant legal provisions involved in the given case. So let's understand grounds of appeal of the assess. So reopening based on same material already examined, no fresh information, independent application of mind is missing, and violation of change of opinion doctrine. So again, change of opinion doctrine reaffirmed that reassessment cannot be a review mechanism. It is not at all. You cannot revisit concluded issues. So requirement of tangible material is necessary, must exist new credible information. So mere reinterpretation is not permitted. That there should be a creditable information available, that is creditable material available with the department for reopening the assessment. So again, section 148, not an empty formality. You must apply independent application of mind, pass a reasoned order, mechanical disposal invalid. So protection of finality assessment, that completed assessments carry what? Presumption of correctness and cannot be reopened casually or arbitrarily. So High Court held that reassessment proceedings in given case it is quashed, and court held that no new tangible material found, action amounted to review only and not a reassessment is what held by the High Court. So principles laid down in the given case that reopening requires what? Fresh tangible material. Change of opinion strictly prohibited. Section 148A must involve a real application of mind from the department point of view. So reassessment powers are not review powers. Please note that. So practical takeaways from the given case: scrutinize what information suggesting escapement, challenge the case based on audit objections or reanalysis, ensure what proper compliance of section 148A procedures, that there need to be just mentioned under section 148 that need to be followed properly. So that's it for today. Thank you. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. If you have not yet subscribed Tax Guru YouTube channel, then do subscribe for latest updates and video series that we are conducting on the Tax Guru YouTube channel. So you are gaining valuable knowledge from all these updates and video series that we are conducting on the Tax YouTube channel. So stay tuned to the Tax YouTube channel. Thank you. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.